Good day, everyone. On my side, it's 12 o'clock p.m. I'm not sure about your time, and it looks like we have a good enough number to start with our webinar today. I just want to welcome everyone to the webinar today. Earlier on, we had a technical glitch. We got a cancellation of the webinar, and we tried to sort it out on our side. If you know that anyone received that cancellation, please advise them that the webinar is proceeding, and you can request them to join, or you can try to dial them into the meeting for today's session. I want to welcome every stakeholder that is here, every homeowner that is here, every occupier, managing agent, or a trustee, or just anyone who is interested in how the schemes environment work. So as you can see, today we are having our first webinar, and we are hoping to have a series of 3 sessions where we will be unpacking our consolidated practice directives that has consolidated all the CSOS practice directives that we've ever issued in the past. So from today, we'll be using this practice directive moving forward as an entire organization, and hopefully our stakeholders will focus on this practice directive in terms of knowing what to do when interacting with the CSOS. Just want to take you through our program today. I hope you can see it on your side. It's not a long program, and I'm hoping that we will stick to the time frames. I'll keep a timer on my side. As you can see that we will have the welcoming from Mr. Melvin Doresami, who's the regional ombud from the KZN area, Free State and Mpumalanga. And then we'll also have the papers from Ms. Malitsatsi Wotini, who is the acting adjudicator general, also responsible for the Capes as the ombud for those regions. Then I will come on board just to take you through the general provisions of the practice directives. And then I will allow for a session for questions and answers. Then we'll get Ms. Kwanda Mulifi, who's a senior manager responsible for governance, compliance, and enforcement. She will take us through the registration process of schemes, and then I'll provide a session for questions from there. Then we will deal with the dispute resolution process, and then we'll have all our senior managers based in the regions, Ms. Tora Sikoliwe, Charmaine Johnston, and Ms. Renusha Mahabir will be taking us through the dispute resolution process of the practice directives. Then after that, we will have a question and answer session. That will be just after 2 o'clock. Then we will ask Mr. Ibrahim Asilo to do the closing remarks for us, as we'll be ending the day hopefully by 2:10. I know the invite said that we'll be closing the presentations, the webinar at 2 o'clock, but we could not fit everything into the program. So I hope that you forgive me for that. And then I'm reminding the speakers that are going to jump on the board today and present to stick to the allocated timeframes so that we can proceed swiftly and be able to end the program for today's session on time. I would like to hand over to Mr. Doresami to take us through the welcoming now. Thank you, colleagues.
Thank you very much, Mlo Vava. Thank you for that opportunity to welcome our friends and industry partners, as well as stakeholders here. We're already excited about the attendance, but what we must also be excited about is the presentation of the practice directives, the understanding of it, and the engagement over the provisions of the practice directives. This, for us, is what will make sense. There are a number of chats coming through. Our administrator will deal with those chats. Some of it is asking for it to be recorded. It is certainly being recorded from the outset. And some are requesting the slides. Our administrator will take care of those requests from the chats from time to time. So a warm welcome to all of you today on behalf of CSOS to our series of webinars dealing with the unpacking of the CSOS Consolidated Practice Directives of 2025. We'll present the topics in the practice directives over the series, and we hope that you attend then as well, and that you invite others to attend. We'd like to see many attend. You know, when we have these sessions in law, we get certain types of people attending, such as managing agents and trustees. We want to see a lot more of unit owners. We want to see participation and engagement. Spread the word. If you are a managing agent, have that message sent out to the trustees and to the community scheme itself. Do not be, spiteful with this invitation. We want participation, we want attendance, and we want engagement. Over the years, for approximately 8 to 9 years, our practice directives have been too fragmented. And finally, we got the opportunity to consolidate them, but not just only put it together as one complete document, but also to have a number of aspects of it corrected. We introduced a number of new provisions and practice directives. But before we did so, and before we finalized anything, we put out a request for the public and for the sector to comment on the drafts that we had in the first place. So it was a draft and it went out for public comment, and we received very valuable and significant comments from industry bodies, from schemes, trustees, and from individual stakeholders and members of the public who felt that they should have a say or say something about our draft provisions. We relied on it. Some of it was accepted and some was not. And at the appropriate time, if you feel that, valuable comments were not accepted, we will be able to respond to you and give you the motivation of why it was included or not included. But what we endeavored to do with the consolidated practice directives is also to close the gaps. We know that legislation is going to take care of much of the gaps and provisions that don't make sense or is causing confusion out in the sector, and the time for legislative amendments will come. But through its operations, we believe that we can bring about a great deal of certainty with the practice directives, which are issued out in terms of the CSOS Act by the Acting Chief Ombudsman. And so today, Umlo, we invite our stakeholders in attendance here to listen in and to digest all of the information coming out. We also ensured that we have the best of the best presenters for you. We've identified all of the managers for the various topics and chapters, and we've asked them to unpack the practice directives for you today. So please sit back, enjoy, make notes, and engage. The program director will take over from this point. Thank you very much, Umlo.
Thank you so much, MD, for your welcoming remarks. Just to hand over to the Acting Adjudicator General, Ms. Malitsazi Wotini. There's a cry that we show our faces once the speaker starts presenting, and then you can switch off your camera. I know it has to do with bandwidth issues. Sometimes we lose connectivity when we show our faces. Just when you're about to speak, can I kindly request you switch on your mic, your camera, and then switch it off. Over to you, Ms. Otini.
Thank you, Mlo. Let me abide. I hope the people can see me. My name is Malitsazi Wotini. I'm the Acting Adjudicator General, Ombudsman of all the Capes. Thank you. Colleagues, I just would like to remind us that CSOS was promulgated on the 7th of October 2016 with a mandate to regulate, to regulate the conduct of parties in community schemes, control and quality assure all scheme governance documentation, to provide stakeholders with training and consumer education, awareness for the property owners and the occupiers. In that context, it is also important to remind all of us that it is a Schedule 3A public entity, CSOS is, and reports to the Minister of Human Settlement. We are here today before you all, and because in terms of Section 36(1), the practice directive has to be done by the chief ombud with the delegation of the minister. So now I think it is the third, or if not the fourth, practice directive that we are dealing with. CSOS will always endeavor to ensure that throughout South Africa, where we've got schemes and our partners and the other entities, and in particular schemes, we do education when and always when we have amended. So it is in that context today, our colleagues, the team, will be presenting to you and allowing you with the opportunity to get to understand and ask us questions where you're not clear. I hand over to you, Chairperson. Thank you so much.
Thank you so much, Acting Adjudicator General. Then I will proceed with the general provisions of the practice directive. Let me just switch on my camera so that people know they are not talking to AI. Here I am. I hope everyone has seen me. I'm just going to switch it off now and then try to share my screen so that everyone can read from the same document that I will be reading from. So on my side, I did not prepare a PowerPoint presentation because the general provisions or guidelines are very short to deal with, but we just wanted to get them done so that everyone can be on the same understanding as we are with the CSOS. So if I will start with the first one. So there we are requiring that all parties should provide the CSOS with, or the representative that has been authorized to provide the CSOS with contact details of all the parties involved in the dispute. Right there, we are trying to minimize the time frames in terms of back and forth, in terms of writing to the party that has lodged an application, in terms of trying to get information. We want to expedite the dispute process so that when we write to all the parties, we do not delay. We want the information beforehand before we can proceed with any process of the CSOS. So we always request the parties to come to the CSOS when they have all the information that they deem necessary for the matter to proceed to move forward. The second one that deals with the parties and stakeholders should conduct themselves in a manner that is professional, courteous, and respectful to all parties. We have seen in the past that sometimes we lose our professionals as individuals when engaging with one another. So it's something that we wanted to address here so that we maintain a rapport of respect when dealing both internally with the CISO staff and externally with all our stakeholders. So it's something that we want to promote at all times because the CISOS is a regulator that serves an industry or a profession that is wide and vast. So we want to treat each other with respect and care all the time. So number 3 speaks to the timeframes when dealing with all CSOS matters, whether it is a time frame that is stipulated in the Practice Directive or CSOS Act or the STSM Act. We want to ensure that we always stick to the timeframes, and we encourage internal people from the CSOS and external people when we write to them that we always stick to the timeframes that is provided there, or it could be a timeframe that we're requesting further particulars or further information from a stakeholder. So we're requesting that the parties should always adhere to the timeframes that we are requesting them to adhere to. When it comes to dispute, whether it's a dispute of resolution, dispute trying to resolve it, or a governance matter, we are requesting people to be furnished with all documents that may they require moving forward. And we always ask that the documents should be made available to all the parties. No one should hoard or try to not submit any document that is required by any party to a dispute or to a scheme governance issue. And then you've always heard us talking about exhausting internal remedies when you want to bring a dispute to the CSOS. Guideline number 5 speaks to that. We want people to exhaust their internal remedies that they have available in their schemes before they bring a matter to the CSOS. And we will, from time to time, we will require proof or evidence that the individual or stakeholder that is bringing a matter to the CSOS has tried everything in their power to resolve the issue before bringing it to the CSOS. However, we understand that there are matters that are urgent that can provide harm to the other party. We will still welcome matters that are brought by an agent basis to the CSOS that relate to issues of disconnection of water and electricity, or not being given access to the scheme itself. Those can be referred to the CSOS directly without exhausting internal remedies. We will welcome those. And as you're quite aware, all our stakeholders, as they should be, that CSOS is trying to digitize its processes. And through that process, we employ a platform called CSOS Connect, and which we are trying to use to streamline all our services that we provide to the CSOS. And we encourage all the stakeholders to make use of CSOS Connect. But on top of that, we will still welcome walk-ins. We will still welcome and take applications when people come to our offices. But we highly recommend that people should make use of the CSOS Connect services that we have procured and made available to all our stakeholders. This process makes everything easy, and it fast-tracks everything in terms of the service that the CSOS can provide to its stakeholders. Then the other one speaks to the language that the CSOS has adopted in terms of applications and in terms of doing its work. Right here, we are saying that we are preferring English as a medium of instruction or as a medium of conducting our work as the institution. However, we will do our best if someone is not conversant in English. We will try our best to assist that individual in terms of providing services in the language of their preference. But at this point in time, we will require everything to be written in English. And then the guideline number 8 deals with all the forms that we make use of as the institution. We are saying that there are annexed here too, and some of them, if you can't find a form that you want to make use of, please reach out to the CSOS. We will try to make the form that you require available to you as soon as we can via email or via any other way that we can make this form that you require to use available to you. And guideline number 4, we are saying that the CSOS and the staff shall guide and support the stakeholders and community schemes in line with its mandate. However, this support shall not include provisions of legal advice, nor will it include investigative powers to either party. So from time to time, as the CSOS, we have been requested to provide guidance or provide legal advice in a form of a question. For example, someone would ask, if my scheme fails to fix a leak for me, and then I go ahead and fix it by myself, am I entitled to compensation? So that to me is tantamount to providing legal advice. So questions where we are required to provide legal advice as the institution, we are going to refrain from, because at the end of the day, the CSOS is a regulator, not a consultant on behalf of our stakeholders. We will try by all our means to provide a service that is neutral and free from any influence. And then we have seen people requesting us to assist them in investigating their complaints in terms of going beyond the CSOS mandate. What we are trying to say here is that we are not going to assist any individual unless that individual is a party to a complaint or an application that is brought into the CSOS and is going through the dispute process itself. That is when the CSOS will be involved in terms of investigating the matter. So we always ask stakeholders to use the correct information or contact details when they are writing to us or when they are conversing with us. So we just want to ensure that the failure to do so might end up in the CSOS not working or doing performing its mandate the best way that we know we can do. So make sure that every time you write to the CSOS, you've got the correct details to contact anyone from the CSOS. And we do have some contact details that you will see on your consolidated practice directives that we have issued earlier on. So please make sure that when you contact with us, you use the correct ones that we have provided here so that we are always on the same page with everyone so that we dispel the notion that CSOS is not responsive. But sometimes we have noticed that people write to the wrong people, and we encourage people also to visit our offices as you can see there, and you can find these contact details on page, just on the page on the practice directive now, page 21 and 20. You'll get all the information in terms of contacting the CSOS physically, or whether if you want anything or you want to write to CSOS. And there is our telephone number. I believe that telephone number, it's a toll-free number, so you can contact the CSOS at any point. And we are trying to be there for our stakeholders, and we're trying to be present each and every invite that we get in terms of doing the CSOS work. That brings me to the end of my presentation right now. I will take questions if there are any. So for me to be able to see the hands, I will stop sharing so that I can see who has their hands up. Do we have any engagement that you would want regarding my presentation or regarding Mr. Doresami's engagement with us, or even the adjudicator, acting adjudicator general, Ms. Wotini? I see a hand from Ms. Wendy Kotze. You can go ahead, ma'am. If you can assist with the unmuting, please.
Yes, I did. She can continue.
Okay, thank you so much. Ms. Wendy Kotze, you can go ahead. You're still unmuted. Ms. Pakizandile, while Ms. Wendy Kotze is struggling. Yeah, there we go.
Thank you, Mlo. It's not Miss Pakizandile, it's Mr. Pakizandile.
Sorry, sir. Sorry.
It's okay. It's okay. It's okay, Bavava. Greetings to everyone online. Mine is really not a question, but is to appreciate that you have taken us through this very important piece of information that, you know, whenever there's a dispute or anything that you, there's an issue in the scheme, you actually encouraging us to have the matters internally resolved, internally attended to first. Because I must also say that even on your on the dispute that is on the application forms itself, there is somewhere where you're asking if has anything been done about this this matter. In other words, if there's any, you know, a dispute resolution, you know, approach that has been taken so far as the matter is concerned. So mine really is to applaud you and to say thank you very much that you actually are emphasizing on the importance of first attempt to resolve issues. Only then you can actually, you know, consult a CSOS. However, I must also appreciate that you are not forcing people to exhaust first the internal processes. For example, when there are difficulties to see that. Thank you very much, Mlo.
Thank you so much, Mr. Paki. Can we go back to Ms. Wendy Kotze? Hopefully she is unmuted now. Ms. Wendy? Okay, Pravesh? Pravesh, if you can unmute yourself, please. Can you kindly assist the people that raise their hands with unmuting?
I have unmuted them. I think it's from their side.
Maybe may I ask through you, Chair, that they write on the chat, then you will be able to take their questions.
Definitely,
That might assist
Ombud.
us. Thank you, Chief.
Thank you so much, AAG. Miss Rosa? Miss Rosa? Frederico?
Yes, can you hear me now?
Loud and clear, ma'am. You can go ahead.
Wonderful. I just want to find out, we've got a dispute that we lodged last year, 2024. It was like mid-year, June, July, and then from August we started the back and front with the emails. We're now in August again, so it's a year. And they still, the feedback that I'm getting is waiting for allocation of adjudicator.
Okay. Fortunate enough, we have all the senior managers in the regions, ma'am. If you can just write the reference number on the chat, I am sure when they come on board, they will respond to your question and I will remind them.
I will do so.
Okay, thank you so much. Ms. Pravesh, we've got a minute or two now to wrap up. Mr. Donald, I can't pronounce your surname, sorry. There you go, Mr. Donald.
Hi, there we go. Apologies, just a quick question. We also submitted the claim last year, and we got the adjudication order now. But in the meantime, all the circumstances have now changed, where now the things that had to take place took place. Now that the adjudication comes, it says that within 6 months we must do a certain action. Let's say, for instance, have an AGM. But I mean, that AGM was held. That now puts us in a kind of predicament. You cannot appeal this to the CSOS because, I mean, that is prevented by law. You have to go to the High Court. But I mean, if the adjudicator now gives a result on facts that did not exist at the time, the implications of that are very serious. So the time lapse that it's taking to do these things, to get to these adjudications, is causing a lot of problems at the moment.
I noted your concern regarding the time frame in terms of finalizing disputes. I'll please write that down on the chat when the senior managers in the region responsible for dispute. I am sure they are going to tackle the issue of time frames also when they are presenting. I have noted that, sir, and I'll raise it with them also. I don't think there are any further questions relating to what I presented. Perhaps if I can proceed at this point in time and invite Mr. Okay, there is a hand from Mr. Abraham Masilo, who is a regional ombud responsible for Gauteng, Northwest, and Limpopo. Over to you, Mr. Masilo.
Yeah, good morning. I hope I'm audible, Mlo.
You are, sir.
I just want to perhaps maybe deal with this last question. That although the senior managers will deal with the timelines and that, but I just want to deal with the main issue, particularly the fact that when the order was now issued, there was now, or the matter was sort of moot under the circumstances. You see, just to indicate that we have actually directed all the adjudicators that much as we note that the matters are slightly old with regards to the backlog that they had previously. We had requested that they must at least ensure that they issue the Section 51 so that they exercise their powers in terms of that provision. When they do that, they will be asking you as to the circumstances and what is now happening as far as this matter is concerned. And it would have been expected, without getting into the merits of your matter, it would have been expected that that would have been brought to the attention of the adjudicator when that Section 51 was brought, to an extent that then the adjudicator would have been aware that the matter is now moot and obviously would have ordered otherwise. However, it's a matter that, again, once we receive the full details in terms of the reference and obviously your contact details will be able to guide accordingly. You must also understand that once the matter is finalized by the adjudicator, we are now what we call functus officio. In other words, we can no longer deal with the matters and we should not provide an advice. However, I think as far as the issue of guidance and for us to be able to understand what could have happened in terms of the issues that I've just explained, I think it's important that you provide us with that the case number, that is the CSOS reference number, and your contact so that we can be able to deal with that at length. I hope I've covered that law for now. Obviously, the others will be dealt with in terms of the normal processes and the delays and so on. Thank you very much.
Thank you so, Mr. Masilo, for your input. I want to give you a chance, Ms. Cecil Maitland, unless you are not going to refer to the issue of delayed adjudication orders. I want to give you a chance because I think we will discuss that at length when there's 3 senior managers responsible for dispute resolution processes at the CSOS are presenting. Ms. Cecil? Okay, there we go. Then can I invite Ms. Nokwanda Mulifi, who is a senior manager responsible for governance and enforcement. She will be taking us through the registration process of all schemes at the CSOS. Ms. Nokwanda?
Good afternoon, everyone. My name is Nokwanda Malefe, and I'll be sharing briefly with you the process for registration. Mine is going to be very brief because if you have a look at the practice directive, it's quite lengthy. We've also included a process flow, particularly what to do when you're registering. So I'm just going to briefly take you through that, and then I'll hand over to questions and answers. Okay, I'm going to switch off my camera now.
I'm hoping we're not speaking while you're on mute, Ms. Nokwanda. Yes, we can see your screen. Just put it on presentation mode for us. You're good to go. Yeah, it's
All right,
okay.
awesome. Thank you so much. So just as I'd indicated in the introduction, that the practice directive is actually quite lengthy insofar as the registration process. So this is basically to just give a broad overview of what is required insofar as registration is concerned. So it is a mandatory requirement in terms of the CSOS Act, read together with Regulation 18, that a scheme has got to be registered with CSOS, and this applies to all community schemes. So this is your HOAs, your share block flats, your sectional titles and so forth. So that registration is something which is mandatory. And then also, as we've indicated in our practice directive, that we're now using CSOS Connect. So all registrations must be done on CSOS Connect. And the reason why we're making use of CSOS Connect is that as an institution, obviously bearing in mind the benefits that we have from digitalization, CSOS Connect for us is the platform that we want to interact with. So we really encourage members of the public to go on and register their schemes on CSOS Connect. We don't do manual submissions, or we don't do manual registrations. However, if you do struggle, you are welcome to visit our offices so that we can assist. But the entire process must be initiated on CSOS Connect by the selected representative of the scheme who's going to be registering. And then that once you have completed the registration process, our office will issue a certificate, a registration certificate signed by the Ombud, and this is to demonstrate that the scheme has been registered. Further to that, we will also be issuing a registration number, and this number is what you make use of when you're transaction with CSOS. This is either for payment of levies or any form of transaction that the scheme will have with CSOS. They must make use of the registration number. This will also include when you are uploading your scheme documents. We're not going to dwell on governance issues today. We're going to dwell on those next week. But just for purposes of this discussion, is that whenever you're uploading your governance documents, you would make use of the scheme reference number to actually get onto our platform. Then insofar as the registration of the scheme, so who can register the scheme, you will note that when you get onto CSOS Connect, you will have to select that you are the person who's being appointed. And the reason why we emphasize that the person who's going to be registering the scheme is a person who's been appointed by the scheme, this is for accountability purposes. So as a scheme, you would have had a meeting where you would then have selected who was going to be the representative of the scheme, and that is the person who's the authorized representative, and that is who you will indicate when you go on to CSOS Connect. So obviously this is different depending on the scheme. It can either be somebody, the chairperson of the trustees. It can be somebody who's part of the executive committee. So any person that has been authorized by the scheme, that is the person that will transact with the scheme. Also, that what is also very important is when you're going on to our processes to register, you've got to select the correct type of scheme. Like I've indicated, we've got different types. You've got your HOAs, your sectional titles, and so forth. And the reason why you've got to make sure that you make the correct selection is that there are different requirements insofar as documents are concerned. For instance, the documents that we request from a sectional title are not the same as the documents that we'd request from an HOA. So when you get onto the scheme, when you get onto the CSOS Connect and you register, ensure that you make the correct selection. And this is also applicable to any managing agent who's been assigned or managing agent who's currently running a scheme. When you register, please ensure that you select the correct platform. And most importantly, also when you're doing the registration, we request that you follow the promptings that are on CSOS Connect. Because it is a digital process, it is sensitive. So in terms of space and so forth, ensure that the spelling is correct. We do know that schemes have similar names. Some schemes have the exact same names. So insofar as inserting the address and the street number and so forth, we request that information to be accurate. And this will then also assist us when documents are being generated from the system, that they've got the correct spelling. We tend to receive many a times complaints that CSOS has issued a certificate which has incorrect spelling, but this is not a CSOS error because the registration is done by the scheme. So when you're typing in, please ensure that your scheme details are properly captured, because what you type in is what you will get on the certificate. And then also in terms of the registration process, we will only issue a certificate when all the necessary provisions have been met. So we do have our registrations team, and they will provide you with guidance and assistance. If at any point you struggle and you're not able to get the information that you require, you're not able to upload any documents, we do have our team online that does provide the necessary support. And once you have registered, you will then receive a certificate together with a registration number. And as previously indicated, this is what then you will make use of when you are transacting with CSOS. I'm just going to stop sharing, and I want to just quickly show you a brief. I just want to go to the page that deals with the supporting documents that you need to provide. Okay, so Vava, are you able to see my screen?
Yes, but
Okay.
it's as if you are loading.
Is it showing the process flow?
No, it's showing my name.
Oh. All right, let me start again.
Yeah.
Okay, can you see
You're
there?
on the right page now. Yeah.
Thank you. Okay, so when it comes to registration of the of the scheme, this is the brief process flow, and this is available on the CSOS Connect. It's also available on the actual practice directives. So this is where we, as the applicant, and this is the scheme representative, you must then go onto CSOS Connect. You will then be required to fill in the details of the scheme. When the documents have been submitted, we then, as the CSOS, will check and say, what documents do you have? Are the documents necessary? And thereafter, you will receive a certificate there. The data capture issues a certificate. You will note that whilst we are on CSOS Connect, there will be interaction between yourself and an employee or an official of the CSOS. And this is where we require additional information. This is where we may then say, look, this is not correct at X, Y, and Z. We do request your cooperation to ensure that we are then able to meet with our timeframes, but also, like I said, so that the registration certificate that you will get from us is one that represents correctly the information of the scheme. And also, there's also various types of schemes. We know that we've got duets, there may be mixed schemes. So when you are not sure what to do, please go ahead and have a look at our practice directive. It will show you what it is that is required from you as the scheme. Then insofar as the supporting documents are concerned, again, these are different. Like I indicated earlier on, that when you do the scheme registration, you have to select what type of scheme you are, and you will see that these are the supporting documents that we will have. So there's difference for the new schemes as well as for the old schemes. So you've got there, for instance, the CS1 form. In terms of supporting documents, it's the constitution, the rules of the scheme, the articles of association, memorandum of incorporation, and there's just a whole list, obviously, which I'm not going to go through, and that's what we'll then need. With regards to existing schemes as well, we've separated this so that you can see what it is that is required from us as CSOS, or what we require from you is the completed form, as well as the schedule of levies of fees payable, the financial statements, and then any other of the following documents that we require for a complete registration. And then again, also for new developments, there's also some information there that you can rely on, that you can then submit to us as CSOS for us to finalize the registration process. So registration is the first step to ensuring that your scheme is compliant. And once that registration has been completed, our office, like I said, will issue the necessary certificate and the registration number. And this is how then you can interact with us as schemes. Mr. Vava, I'm going to stop there for now. And then if there are any questions, we can take questions. I'll hand over back to you. Thank you.
Thank you, Ms. Mulifi. I see there's a hand from Ms. Lerato Miyaka. Ms. Lerato, you can go ahead. Okay, the first one, I do not know what happened, is Nicole Nell. Ms. Nicole Nell, you can go ahead. Just unmute yourself.
Good morning. Oh. Nicole, you can go ahead, or I can proceed.
You can proceed, Lerato.
Good morning, everyone. Not to workshop the issue, I just wanted to speak about, as somebody who interacts with the CSOS Connect tool on an every other day, is that I think the tool sometimes is not communicating properly, because even though I have schemes that I've been issued out with the compliance certificate, I did receive a notice that those schemes are still not compliant. So I'm not too sure, maybe that's something that is internal that maybe you might just need to take into account to say, we are trying to use the tool. We even go all the way to get the certificate that we are compliant. Then again, you get hit with the document, an email that says you're not compliant. So I'm not too sure where the discrepancy is there. Thank you.
Okay. Ms. Mulifi, you want to address that?
Thank you. I was just going to ask, when you say you've got a compliance certificate, so yeah, I think if you can just, that's quite broad in the sense that, for instance, if you register the scheme, there's the registration certificate, you'll get that. If, for instance, you've got rules, you've updated your rules, we issue a certificate either in terms of Section 10. Where exactly is the process? I think if you can just unpack that, then we can be able to direct where does it say compliant. Because, for instance, if you go onto CSOS Connect and you register, then it'll ask you for particular documents. We had I think I met about 2-3 weeks ago, somebody was trying to load their constitution, but the print on the document was quite, it was very faint. In fact, it was too small, and the CSOS Connect then kicked it out and said not compliant, because when we opened it, it comes open as a blank document. So obviously you can't just upload a blank document and refer to that as the governance document. So we did have a meeting with that individual together with IT, and we sorted that out. So there's different stages, and for every stage that you complete and correctly upload the necessary documents, you will then be deemed as compliant, or you'll be referred to as compliant. So with your case, is there a particular aspect? I think that will assist us to give you a more fully rounded response.
Okay, so within my case, I registered the scheme up until completion. So until the tool itself said I'm compliant, and then there was a certificate that was issued to say the scheme is now compliant. But then 2 weeks ago, I got a notice that the schemes that I've registered are not compliant. And although they referred back to all the documents that I had already loaded and were accepted. So that's why I'm saying maybe there's a miscommunication in what is on CSOS Connect and the guys that were doing the verifications of the schemes. Because we have received the compliance certificate as well, but then then I got this notice to say we're not compliant, to a point that we even received the statements as to what levies were due for those schemes. But then again, then that I'm saying maybe it's something, maybe I can give you the specific reference numbers and then we can just look at that, but offline, of course. But it's just something that I just wanted to bring to the platform.
Definitely, Ms. Lirat, I
Thank
was
you
going
so
to
much,
suggest that also. Okay, I think the lady left. Can I go to Ms. Ronnie Govender or Mr. Ronnie Govender? If you can unmute yourself, sir. Please unmute yourself, Mr. Ronnie Govender. Okay, seems as if you are struggling. Can I move on to Trom? T-R-O-M?
Yes. Hi, can you hear me?
Loud and clear, sir.
All right. I just have 3 questions. One, in regarding CSOS Connect and the initial schemes verification, what is so different now compared to what you had done? Because you had even sent field field officials to come and verify the schemes, and we were asked to do that. That was last year. And then we, at that time as well, received our registration certificate, or it was confirmed. And so I'm slightly confused as to why the mandatory shift to CSOS Connect, and how different is it from the initial schemes verification that was done a year or 2 ago? That's the first question. 2, I think Nokwanda, is it Nokwanda who was representing the existing schemes? We're not a phase development. I mean, we're existing scheme, and it wants supporting documents. I saw there. I'm not sure whether those are optional or those are mandatory, because if she can go back to her slide, there's the first 3 where it requires I think it's, I couldn't read as fast as she was presenting. And then at the bottom, it says supporting document, and I'm putting that in inverted commas. Now, I'm not sure whether that is that host of things are actually required over against the 3 that seem to be mandatory. The reason that this, which is my third question, is usually managing agent changes. And now I see the requirement is at the AGM, we need to have appointed that. AGMs happen anytime during the year for various schemes. And so we are trying to register ourselves now as the scheme, and I as the chairperson. And our AGM has not happened, but I have a director's resolution that was signed. And I'm not sure how to go about now that, because if a managing agent changes, then we need to update those details. And we prefer to have the scheme registered as itself. And whatever managing agent or not comes in later, we simply are in direct communication with the CSOS.
Thank you so much, sir. Ms. Mulifi?
Thank you. I think firstly, just to address the first question with regards to VNV and CSOS Connect. So the VNV is a project that CSOS has embarked on. We are now on phase 2. And this is for us as an organization wanting to find out the number of schemes, the actual number of schemes we have in the country. And that is why we had our field workers, and we still have our field workers going out and verifying the details. The reason why we're doing this is because currently we do not have an exact number of how many schemes there are in the country. Insofar as our registration numbers, I think we're sitting at just above 30,000 schemes registered, but we do know that that's not the full amount of schemes we have in the country. So the purpose of the VNV is for us to check how many schemes there are. We've checked with the Deeds Registry's office, we've checked with CIPC, we've checked, with various sources, and across all sources, there is no exact amount. Now, as a regulator, we obviously have the responsibility to ensure that we understand the universe that we're functioning or operating within, and that is why we've got the field workers that are going out now and checking the number of schemes registered. And that's why we are encouraging scheme registration. Registration has got to be done by the scheme. I see Gigi is saying they don't even know. The reason why we don't know is because you're not registering. The responsibility to register rests on the scheme. And that's why we're encouraging scheme to register. I think, unfortunately, our legislation doesn't allow us to penalize people for non-registration. So whilst we're trying to bridge the gap, we're then saying, let's get field workers to go out there and find out how many schemes there are. So I think we shouldn't confuse that process. So the reason why we're doing the verification is so that we know how many schemes there are. And if we can then go on to CSOS Connect. CSOS Connect is the medium through which we are transacting with members of the schemes. And I agree with you, Mr. Trom, insofar as saying that you've got the resolution where you have been assigned to proceed and register the scheme. Please go ahead and register the scheme out. We see that as some schemes that are managed by managing agents normally hand over the responsibility to register the scheme, but you are welcome to go ahead and register the scheme yourself. In fact, that's the correct approach. As the trustees of the scheme, you obviously have a fiduciary duty towards the scheme and to ensure that it's compliant. So in that regard, you can proceed and register the scheme. Insofar as the supporting documents are concerned, they're not optional. We've obviously listed various documents. Like I said, depending on the nature of the scheme, some documents you may have, some documents you won't have. Also, with a new scheme, there's certain documents that we won't ask for a new scheme that an existing scheme may have. So if you have a look, I think on the invitation there is a link to the practice directive. The practice directive also is available on the website, and there it will show you exactly what documents are required from which type of scheme, whether it's an existing scheme or a new scheme, and also then specifies if it's an HOA, a sectional title. There you will find what documents are required from yourself. So VNV is a process that we are doing to verify the number of schemes, but you must still interact with CSOS Connect. What we then do with information that we've received from the VNV, we go and align and check whether is the information aligned, is it correct? And this will also to assist us with duplicate registrations. We do find sometimes that people will register themselves multiple times for whatever reason, and so the VNV process will assist us even then in identifying schemes that have been duplicated. We are aware of the challenge, and this is something that as CSOS we continue to address. It is a work in progress. Also bearing in mind, like I said earlier on, that schemes have the same numbers. So when a scheme member goes onto the CSOS Connect and uploads the exact same number, same name, and then an incorrect street address, that can also cause problems. So I think I've covered those three questions, Mr. Vava.
Thank you, Ms. Mulife. Back to Mr. Ronnie Govender.
Hi, good afternoon to you and your team there. And I must thank Jerusha for the invitation. I've got two questions in terms of governance. Can you hear me?
Loud and clear, sir.
Sorry about that. Yeah.
But
the voting,
can I just jump in that before you ask your question? If it's relating to something else that Ms. Mulife did not present, we are not going to be able to respond to it right now because we're going to deal with all the governance requirements later on next week. But I'm hoping your question relates to what she presented on the registration of schemes.
Okay, since I have this question, I'll wait for the next week one. But just on I'm a bit actually perturbed to hear, if I heard it correctly, that not all scheme holders or body corps are registered. Is that not? And you indicated that it's not legislated requirement. Is that true, or misunderstanding that?
Ms. Mulife?
It's a complete misunderstanding.
Okay.
What the introduction was, it's mandatory for all schemes to register. What we're noting is that not all schemes are registered. And if you have a look at our legislation and the regulation, the responsibility to register rests on the scheme. Now, that's why you have trustees in the bodies corporate, and trustees have a fiduciary duty. And one of the duties is to ensure that the scheme is properly run and properly managed. And the first thing that you need as a scheme in order to to function in accordance with the legislation is to be registered. So we implore all the chairpersons of body corporates, the trustees and so forth, to make sure that you register. And even if you're not a chairperson, if you're a member living in a scheme, you must notify your scheme that there's a requirement to register, and you must register. The challenge we're having now is that we don't have any punitive measures that we can place against schemes for not registering. And so that's why, as an organization, we're on this drive to promote and raise awareness about registration, about the need for it to be done. So we do ask you to just make sure that your scheme is registered. If you're not sure, come and check on CSOS Connect, ask the managing agent, ask the trustees, but please be the agent of change and get your scheme registered if it's not. Thank you.
Thank you very much.
Ms. Mili. Mr. Kitsope. If you can unmute, sir. Can you kindly assist Mr. Kitsope to unmute? While you are there, you almost got it right, Mr. Sobe. Just unmute, sir, please. While Mr. Sobe is struggling, can we kindly move to Hazel? Miss Hazel Radamia? If you can kindly unmute yourself. Miss Hazel Radamia? Can you kindly assist the colleagues to unmute? I'll go to Marieke. I hope I pronounce your name the right way, sir, or ma'am. Maryke. You can go ahead, ma'am. It seems that our colleagues are having challenges in terms of...
Okay, I've unmuted. I had a little bit of a problem.
There you go, sir. You can proceed.
Thank you. It will be a quick one, and you may say to me, I must ask it another time. We've got 3 body corporates under sub-association, NPC. Rights have been assigned to the NPC. We've updated our MOR and conduct rules, and we've been told by our lawyer that we need to register the new MOR in terms of the Companies Act, and we're busy with that. But we do not need to register either the new MOR or conduct rules with CSOS. Yes or no, correct or not?
I don't think that question deserves a yes or no answer, but I'll hand over to Ms. Mulifi or any of our colleagues who would want to assist in this regard.
I think you should ask for a refund. You have to register a scheme. You know, if you for as long as it's a community scheme, and it falls within the definition of a community scheme, please do register it with.
Sorry,
with
CSOS. It is. Sorry, that's why I'm asking. I may be not
it's
asking
mandatory.
the correct. So it is registered, but our new conduct rules and MOR do not need to be registered with CSOS. That's my question. We are registered. The 3 body corporates are registered. But what I'm saying is we've changed our conduct rules and MOR, and that we don't have to register those new MOR and conduct rules with CSOS. That's my question.
Before you jump on this, I see there's a hand from Chantal Kutzen. She's one of our CEIs. Chantal?
Thank you very much, Bava, for the opportunity. Good afternoon, everybody. So just to clarify, with a body corporate, it is mandatory for the conduct rules to be submitted to CSOS for quality assurance. With an HOA, with your MOI, or with your constitution, or with the conduct rules of an HOA, it is not mandatory. Currently, it is an optional or a voluntary process. So body corporates don't have a choice, and HOA have a choice in the matter as long as it's registered with or submitted to CIPC. It's voluntary to submit to CSOS for quality assurance.
So thanks, Chantal, but you haven't quite said yes or no. We have 3 body corporates, but they have been assigned to the company. The company is proceeding with CIPC, etc. But we don't, my question, we don't have to register the new MOI and conduct rules with CSOS.
Okay, so according to how I understand it, and I do not work in that department, I do not work for quality assurance of rules, but I deal with it on a daily basis as a compliance and enforcement investigator. The three body corporates would have a masters association, which is the HOA. So
That's
normally
correct.
the three body corporates have their own internal rules as well, and then there's an umbrella set of rules for the HOA, if I can call it
Correct.
like that.
Correct.
So the body corporates, each of their own rules must be quality assured, and the HOA, it's voluntary.
Okay, so they were originally quality assured and registered, and now it's the company that's submitting the MOI and conduct rules.
It
So
does not have to.
does not have to. Correct. Thank
No.
you. Okay. Thank you.
Thank you.
Mr. Masilo?
Yeah, I'm covered. All
Okay,
I can
thank you
say
so
is that
much.
all the body corporate rules must be submitted, and the word "must" it's bolded. Failure to do that, those rules will not be applicable, will be invalid. Thank you.
Thank you so much, Mr. Masilo. I've got a hand from Hazel Ratami. I hope you can unmute this time around.
We can try. Are you hearing
There
me?
you go.
Right, thank you so much. There's so many little mics. I wasn't sure which one to click. I do apologize. So I just thank you for the directives, for this. It's wonderful to be able to sit and listen with everybody and have the questions answered. Mine is on CSOS Connect, where I have registered several schemes, only to find that in the course of a period thereafter, I get given emails, I get sent emails requesting all the documentation that has been registered on the CSOS Connect to please be sent to this specific individual or this person. I've been issued the certificates. I second what this other lady, just two ladies before, or two people before this one, where she was saying she seems to think that, she's got a certificate, everything's compliant, then you get a letter saying you're not compliant. Please, can you submit this? And this regards to, I understand completely if you have a blank document, if you have a rules that you can't read, but all the documents are submitted on CSOS. That's your rules, your financials, and then I get an email from somebody. I have them from Cape Town to Pretoria to KZN asking me for the documentation that is already on CSOS, and please, can I submit it? I have to say it is extremely frustrating for me to have to duplicate and sometimes triplicate the process, and I don't understand the need for it if all the documents have been put on the CSOS Connect when I registered.
Thank you, ma'am. I've got a hand from Chantal.
Thank you again, Vava. Hazel, so I think the letters that you have received might be from compliance and enforcement investigators such as myself doing a compliance check. So when you register a scheme on CSOS Connect, there's a few documents that's required. For example, a certificate of establishment, a sectional plan, conduct rules and so forth. So when we do a compliance check in our department, there is plus minus 10 documents that we require. Normally, all of those are not uploaded on CSOS Connect, or it is labeled incorrectly, or, for example, the audited annual financial statements is unsigned, or it is just annual financial statements drafted by an accountant. So there's various things that is not correct. So it is the mission of the CEIs, that is our sole and core function, to get all the schemes compliant in South Africa. And by compliant, it doesn't mean registered. It doesn't mean just annual returns. It doesn't mean just paying CSOS levies. It is to ensure that there's appropriate insurance policies in place, that if it's managed by a managing agent, that we do have the management agreement. It goes above and beyond. There must be a 10-year maintenance plan, a reserve fund levy, and so forth. So please just cooperate with us. We are also under a lot of pressure to get all the schemes compliant. And we understand our first point before we send out, I just call it a love letter, before we send out that compliance verification letter or the non-compliance notice, we do go on CSOS Connect first and we check what is there. So normally we just request the additional things or things that is incorrectly uploaded or not there. I hope that answers your question. Thank you.
Thank you, Chantel. I have to disagree, and if I can get your email address that I can actually send you, because many instances where I have uploaded the actual documents I'm asked for, I have no problem in documents that are not on, for instance, if you're looking for plans or agreement, I've never yet been asked for a managing agent agreement. I wouldn't even know where to upload that, to be perfectly honest. But all my other documents are submitted, and I'm consistently asked for duplication, and this is what I don't understand. But I'll leave it there with you. I appreciate that, compliance is something that's imperative to me, that we're on the same page, but I just don't understand the duplication. Then I've got one other question. When the new documents come out from CSOS that you update yourselves with on a continual basis, your CS1 and your annual return and your other documents, they are continuously being updated, but I do not find I'm notified or I'm aware, and not that I expect an individual email, but somewhere along the line, I land up using an older form. Where do we know when an old form has been replaced, updated, or is available? I've been to certain training sessions where there are documents that I honestly had not seen at all, because I didn't know they were available. How do we quantify this?
I think a good starting point is our website. Normally, the most up-to-date documents is on the website.
Okay.
I will post my email address again in the chat box. So if there's anything specific, if I don't have it, for example, if it's with the finance department, I have colleagues everywhere I can assist. So I'm just going to pop it in the chat box.
I'll be so grateful. Thank you.
Thank you.
Thank you, Hazel and Chantal. Can we go to Clara? There you go. You can unmute yourself now, ma'am. There we go.
Thank you. Hi, good afternoon, everybody. I've just got two queries as well. One is based on something that was asked briefly earlier with regards to the VNVs. With our one branch that's in Newcastle, I've recently been requested for that information, so that's fine. But when I've been trying to inquire about Pietermaritzburg, because there we've got a slightly larger database to have to get all the documents together and ready for, no one's able to assist me. So when can we expect those VNVs for Pietermaritzburg?
Ms. Nogwanda?
Thank you. Just please be on the lookout, because our service providers are literally moving around the country. The process is ongoing up until next year, February. So they will be moving around, and as soon as the service providers have reached the area, then they will issue letters to yourselves, then requesting that information. So our service providers have been allocated various areas, and as they move along, they'll be in touch with you.
Okay, perfect. And then the second question is also with regards to CSOS Connect. Is there an easier way to change information? One of the members in the meeting asked earlier because they don't want the managing agent involved with the registration, because otherwise when the managing agent changes, they've got to try and change that information. We are a managing agency, and at the beginning of this year, we had taken on a client from another managing agent. And instead of delinking the community scheme from their CSOS Connect profile, they ended up deregistering the community scheme completely, which I'm sure you can imagine was a nightmare for us to have to pick up that piece and get it sorted and get it fixed. So is there an easier way to change or delink and relink a community scheme from one profile to another? And second to that, what is CSOS's input on making it a little bit more difficult to deregister a community scheme accidentally? Because obviously if a community scheme is deregistered and is now changed into, it's no longer sectional title as an example, and now it's been registered as something else, then of course we can deregister it from CSOS. But in terms of just accidentally clicking a button, surely there should be some form of resolution in place or some form of check to make sure that the community scheme actually no longer exists in order for it to be deregistered from CSOS.
Ms. Mulifi? Or can we get any of the regional managers, ROMs, if they are on the call, in the call? Ms. Mulifi?
Thank you. That is a mouthful, as you asked. I think
Sorry.
no problem. I was actually going to drop my email in the chat and ask that we chat offline. But insofar as the what you've just outlined, where the scheme was previously managed by another managing agent. For clarity, did the former managing agent deregister the scheme without the scheme knowing, and now you're trying to re-register? Because it would have just been a question of handing over. Because if you're now deregistering the scheme, that means when we register, we'd have to issue a new registration number. What was the actual?
Yes, so instead of delinking the community scheme from their CSOS Connect profile, they deregistered the community scheme with CSOS. So we basically had to re-register the scheme with CSOS, and we've gotten a new registration number and everything. So we did manage to get it resolved, thankfully. But just to prevent something like that from happening again, because I've never tried to deregister a community scheme, and as managing agents, you gain clients and clients move on as well. And I can't say that I've personally ever experienced this problem where I struggle to de-link a scheme to an extent of deregistering it. So I just wanted to find out what can be done, because also the last thing a trustee needs to do if they do it themselves is now the chairperson changes hands and accidentally or a trustee is no longer a trustee, and then they accidentally deregister the scheme instead of just delinking it. So that was, ultimately the first part is to not deregister a scheme accidentally. But then also, is there an easier way to change the profile? So if community scheme A is currently with this managing agent, just to delink it and link it to the new managing agent without having to go through all of the steps of uploading the documents and stuff again, apart from maybe the management agreement or a resolution to change the managing agent.
Ms. Mulifi, we are 2 minutes over your scheduled
We're
time.
over time. Yes. Look,
Can I ask you just to put your email
there,
address in the chat, and then I'll send you an email?
Yeah. Oh, okay. It's fine. You can send Nokwanda email. I thought maybe I will quickly address, just to indicate that we are addressing that issue. We have noted that with our IT to make sure that all the schemes that are registered are not deregistered on the system, because it is somehow illegal to deregister the scheme. Once it's registered forever. You cannot deregister, and therefore it's an IT issue that we are also looking at. But we will obviously discuss it outside of this with Ms. Molefe, you and Ms. Molefe, and obviously it will come to my attention and we'll address it as well. Thank you very much. Thanks.
Perfect. Thank you so
Mr.
much.
Masilo. I've got Sin or CN, CYN.
Good morning. My question is for the board. Earlier you said that there is no action that is taken against community schemes for not being registered. Is that correct?
Ms. Mulifi?
It's not that there's no action taken. That's why we've got our compliance investigation officers, and they will send out compliance notices and issue a notice and say we know that we're not compliant. However, what we're saying is the duty to register rests on the scheme. Our legislation does give us powers where there's a failure of compliance on the part of the scheme in terms of our Section 34. But that's not that's not the step we want to take as the regulator. What we want to do is to encourage members of schemes or the community schemes in general to comply and register. We don't want to do that, but if needs be, obviously, I think we would then want to move to that. But we don't want to promote an adversarial culture of constantly dragging each other to court for simple things such as registration. Yes, our powers are limited, but it's something that can be done, but we don't wish to promote such a culture.
I hope
Sorry,
you recover. You can go ahead, ma'am.
Sorry, so what I'm just trying to get clarity on is there are no penalties for the scheme for non-compliance. Is that correct?
There are penalties, ma'am. We do have Section 34, which where there is no compliance, where there's non-compliance, you can get imprisoned or there can be a fine, depending on what the court deems fit when we do present. So there are penalties. What we're saying is that as a regulator, we haven't been exercising those powers because we want to promote a culture of proactive compliance. But if needs be, then the CSOS does have the power to take non-compliant schemes to task.
And at what point will a scheme that is non-compliant have those additional measures levied against them? Is it if they're non-compliant for a year or non-compliant for 2 years? How much leniency and leeway is a scheme given in order to become compliant once you have issued a non-compliance notice?
So our compliance investigators, what they normally do is they will send out the letters, firstly notifying you that, look, we see that there's X, Y, and Z. Please, can you submit the necessary information for you to be compliant? They even go as far as developing compliance plans, and it's only after we've exhausted all of those measures that we can then, as a CSOS, decide to take a scheme to task. But like I said, we haven't initiated that process as yet. It's something we want to explore, but to avoid a constant legal battle and an adversarial approach, we want to then encourage schemes. So at this point in time, we haven't really taken those steps. But if we find no joy with the scheme, then we obviously will have to consider taking it and enforcing.
Just to take it further, just to take it further, you would note that we have also introduced the collection, wherein we will then do the civil approach, in terms of the civil law, to go for the collection of those, obviously outstanding levies. And again, also on the registration, we will embark on that using the similar method in terms of, the appointed attorneys that are busy with that area of non-compliance. However, if you listen to what Ms. Molefe is saying, is that we are very reluctant to have you or any of you, have the criminal record, because we are avoiding the adversarial, approach in this. But we will obviously make that decision. But at this point in time, we have not yet made that decision, purely on the basis that we still want to be non-adversarial and try and deal with these matters in a more cordial manner until such time that there is clear non-compliance that will obviously force us to obviously follow the provisions of Section 34. But we have not yet done that deliberately. So thank you.
Thank you so much, Mr. Marcelo. I hope you are covered.
No, sorry, I have another question. I have a further question as well. I appreciate that CSOS doesn't want to be adversarial in nature, but as with all laws in the country, if they are not enforced, if there are no consequences for complexes, then there is no compunction in anyone breaking the law. And that for me is a problem, because CSOS is 8 years old now. And if CSOS in 8 years has not yet enacted clause 34, then rightly so, complexes are going, CSOS, SMESOS. It has no power. It does nothing. It means nothing. We have no respect for it. And that is the problem with complexes at the moment. And I'm speaking from experience. And I think Mr. Masilo may have recognized my voice by now. Yes, it is a big problem. And I think CSOS needs to do something about changing that tide. As I say, you are 8 years old. And if you want to be taken seriously as a body, you need to actually start enforcing the law and start being taken seriously. If there's no consequence, there's no enforcement. And we all know without enforcement of the laws in the land, you have anarchy. And that is what's taking place with managing agents and with complexes. And to find yourself in one of these complexes is a very, very dangerous position, because you get targeted by the other owners that don't wish to be compliant for various reasons, because obviously they're not adhering to the rules and regulations. The very reason that CSOS was brought in is to ensure that complexes are compliant and that all owners are safe and secure in their investment, that they are not going to have rogue agents taking advantage of them. And if you're going to meet that objective to protect the average person, then you actually need to start with the punitive measures. Much as you don't want to say adversarial, well, then you could say our courts in general are adversarial. No, they're not adversarial. They simply meter out crime punishment. They assess if there's been a crime, and then you are punished accordingly. But if we're not going to punish, then there's no need to follow the law.
I think you've made your point.
And then
Yes,
on the
I
other
think you've
point,
made your point. Yes.
Thank you.
And
I will
I
move
said
along.
to you that we will look at it. And I think we hear you. The adjudicator general is here as well. Obviously, we'll note that and we'll take it from there. Because I don't want us to now deliver to labor on this issue, more than the other issues that we need to deal with here. Thank you very much. I think we have.
Thank you. So then the other question that I have is, with CSOS being aware of complexes and their existence, and actually approaching the complexes other than just feet on the ground, knocking on doors, on the procedural requirements 9.4 of the circular on registration and submission of annual returns, it says the CSOS will pursue the list of non-compliant community schemes from the Independent Regulatory Board of Authorities and notify those community schemes which are non-compliant and issue a non-compliance letter. Is that yet being done?
Ms. Mulifi?
Yes, it is. We issue non-compliance notices to schemes. That is part of our daily work.
Sorry, you're misunderstanding me. I'm not talking where a scheme comes to your attention through feet on the ground, but are you actively monitoring the IRBA auditors' reports for non-compliance of community schemes?
Yes, we do. We do have a
Chantal,
relationship
if you
with
can
EDBA.
also jump in.
Thank you very much. So the governance managers are in contact with IRBA on a monthly basis, and they basically allocate to CSOS all the schemes that is not compliant in terms of IRBA's regulations. And then we pursue that, that way, and we have to report back to IRBA as well. So yes, we are actively working together with IRBA on the non-compliant schemes. Thank you.
Thank you so much, Chantal. I think you are covered now, ma'am. I see that we also have few hands. Can I request that colleagues, you write your questions on the chat? What we are going to do, we are going to get responses from the relevant people, and then we are going to send the responses directly to you, colleagues. If you write your question with your email address, we promise that we will respond to you within 7 working days. So we just to keep in time and honor the time that we scheduled the webinar for, I think it's prudent for us to move on to the next presentation. I know the compliance and enforcement topic is always a burning issue, and that's why we've dedicated a separate session for it next week. So can we please hold on the questions so that when they present, we can have the questions ready for them in advance if it's possible. Now, can I call on the senior managers responsible for disputes to come on board and take us through the dispute resolution processes? Thank you so much. I can see they have shared their screen already. Over to you, colleagues.
Thank you, Mr. Vava. Good afternoon. My name is Charmaine Johnston. I trust that you can hear me because you can certainly not see me as a result of the fact that I've been dispossessed of my laptop recently, and I'm working on something that resembles a laptop but is not very good on the camera side. So I do apologize for that. As I said, my name is Charmaine Johnston. I'm a Senior Manager Dispute Resolution for Gauteng, Limpopo and Northwest. And this presentation was prepared with the assistance of my counterparts in KZN and Western Cape, Ms. Sikoliwe and Ms. Mabir. They will ably assist me in presenting this presentation to you today, as well as to take your questions afterwards. Our brief was to look at the practice directive, which we are very proud of, the new practice directive, which is consolidated into one to make it much easier. We are not going to take you through clause by clause of the practice directive, but we're going to highlight a few instances where there has been changes, and then, move on to the general type of areas of dispute resolution. So we're going to deal with it on the basis of assessments, what has changed there, conciliation, and then ultimately at adjudication. In order to do so, we have prepared a presentation, as you can see, and you will note that ultimately buying into a community scheme, the CSOS is there, amongst other things, to ensure that we have harmonious living. In reality, dispute resolution has to take place because that is what the reality looks like, and it's definitely not always harmonious by nature. So the CSOS have been evolving. We have looked at our practice directives to consolidate same, and as I said, we're going to focus on what is new and reiterate some important issues. We have received extensive commentary, as has been mentioned by the Ombud KZN, and we've had many a session in conjunction with our legal representatives and ultimately settled the practice directive in its current format by Senior Counsel. So the new practice directive came into effect on the 18th of July of this year, and you will see that the dispute resolution portion thereof commences on page 158. So you will also note that this is not a legislative amendment. We are very much bound by what the legislation permits the CSOS to do and what we can do in accordance with our mandate. But the practice directive is consolidated to assist in the existing process and to amend smaller little things that we can do without having to approach the legislator, the parliament, for legislative amendments. That process has, however, commenced, and we hope that in future we will call upon you to even make further comments with regard to what you would view as legislative amendments that we can then position in the correct forum. So please don't expect that we can change anything regarding the legislation with our practice directive. And this is purely an internal guide for direction to our internal employees, as well as our external stakeholders. And we can assure you that this has been aligned with our standard operating procedures. So as is mentioned before, you have been chatting about CSOS Connect on the governance side. We are moving from a SharePoint tracking system and migrating onto CSOS Connect as well on the dispute resolution side. This will be fully functional within the next few weeks. And we're certainly excited to share with you that this will make things a lot easier on the dispute resolution side as well. Something that came about on our practice directive is certainly the fact that we need to limit our submissions that we receive from applicants not to exceed 10 typed pages, excluding the annexes. We really need to emphasize that this is a practice directive amendment that we want you to adhere to in order to make sure that we can give your matter the attention it deserves and that we can get crisp and coherent submissions made to the CSOS. Then, in addition, you will recall that our application form would have mentioned at the signature portion thereof that personal information and everything that is submitted to us will be utilized in the resolution of the dispute. But we can assure you that in terms of our POPIA prescripts, we will be redacting any information of a personal nature, and this is now also embodied in our practice directive. Our case management officers will determine the validity and jurisdiction of an application, and they will also determine the necessary locus standi of the person bringing the application. So that just precedes what we do before the matter really takes off. Condemnation is the next step that they would be looking at, and you will note that this is no longer an ex parte application. So this is one of the important changes in the practice directive, and you will see that in the past we would have looked at any type of disputes received where it relates to a decision that was taken at a meeting. And if that decision was taken in a meeting more than 60 days past, we will then require the applicant to apply for condonation. In the past, we have only called upon the applicant to deal with this application and then considered same, and ultimately the Ombud will make a decision on whether the condonation should be allowed or not, whether the reasons granted is sufficient or not. And then the matter would either be proceeding from there or it would be dismissed at that juncture. As you know, this is a very much a suspensive type of condition in our process, whereas once the condonation application is not successful, that's basically the end of the road. And if it's the end of the road, obviously it means that we close our file. However, in terms of the audi alterum partem rule, which basically just means that we need both parties to be heard, condonation applications will in future be dealt with not on an ex parte basis, but on the basis that both parties need to give input in whether this matter should proceed or not, whether the condonation should be granted by the Ombud or not. So that's just an extra leg in terms of fairness that's been introduced from a condonation perspective, and that it is something that would go a long way in ensuring that we deal with all these type of matters in a transparent manner and to allow all parties to have their say with regard to whether condonation should be granted or not. So after that condonation process is completed, the CMO will exchange the statutory notices. We know that you're well aware of section 43 and 44 and what is required of you. What we can also now mention in terms of the new practice directive is that the CMO, the case management officer, is now empowered to assist with settlement agreements once those section 43 and 44 notices have been issued. So this is important in order to allow for a more streamlined process and not to be prescriptive in how we deal with especially settlements only at the conciliation stage. It will be very valuable for our case management officers to be able to assist in this because, as you know, the CSOS is seized with volumes and volumes of complaints. Just in terms of the last 4 years of which I can account for, we have almost trebled the volume of applications that we receive for dispute resolution. So if we can, in the spirit of conciliation, settle matters earlier in our process, this will give a case management officer the opportunity to assist with just that. Then obviously, in terms of Section 42, the rejection of applications, just again to highlight this, and that it's more set out in more detail in our practice directive, we will be able, or we will have to, or like Mr. Masilo always say, must is the operative word, reject an application if the managing agent did not submit a resolution authorizing the agent to act on behalf of its principal, either the trustees or the directors. We also must reject the application if there's no director's resolution in the instances of a company. Furthermore, if neither the owner or if it's neither an owner or an occupier dealing with the application or a person that has no material interest in the matter, we also can't take the matter any further in terms of our legislation. And then obviously, if there's no legal connection, like it's simply two schemes that are adjacent to each other, but there's no legal connection between them. Again, also, if there's representation by another party, where it is permitted in the CSOS Act, if we don't have the necessary representative requirements that we call for, we also are obliged to make sure that this matter doesn't go forward and it's rejected at inception. And lastly, and most importantly, if the matter is part of or closely related to court proceedings, we certainly can't proceed with the matter at the CSOS as well. Then my colleagues have asked me to also mention that we cannot emphasize enough that parties need to check their junk mail and spam boxes, because we do place the onus on the parties to ensure the receipt of CSOS correspondence. We found in a lot of instances that people complain that these correspondences issued by the CSOS fall into a junk mailbox. We really need to implore you to check those things regularly to ensure that you receive our correspondence and that you are aware of what is happening with your dispute. Then on to conciliation. If we look at the role of the conciliator, it remains the fact that the conciliator can only facilitate discussion to reach an amicable agreement to settle the matter, and this is done then on a win-win basis. We have to reiterate that the conciliator has no decision-making powers, and if the conciliation is not, excuse me, if it's not successful in resulting into a settlement, the matter will proceed to adjudication. A certificate of non-resolution will be issued in those instances. And we also need to emphasize, as we have now implemented in our new practice directive, that any and all recordings that we use is purely for internal purposes. This is not to be used in further proceedings, especially in the case of a conciliation, and it is for our quality assurance and purely on a without prejudice basis. So we receive a lot of requests for recordings, but you have to appreciate that this is not something that we can share, especially because a conciliation is on a without prejudice basis, and none of what happens in the attempt to settle the matter by conciliation can be used afterwards in an adjudication setup or externally in a court of law. Then, in terms of the settlement agreement, if there was a settlement reached, we implore, in terms of the new provisions of our practice directive, that this is being signed within 24 hours, failing which we will have to proceed to adjudication. We've experienced a lot of delay in receiving the final settlement agreement signed by the parties, and we often assume that it's because parties are so happy that the matter is finally settled that they forget that we have a process to complete. So, with that being said, we also know that we can, at the moment, permit face-to-face or hybrid conciliation sessions. If COVID has taught us anything, it is important that we have these type of sessions virtually at the moment, but also to allow parties on request to have this done face-to-face. or by way of a hybrid session. You will appreciate that we can't compel people to come to our conciliation hearings physically. So if there is a need for a person to attend on a hybrid basis, this is now incorporated into our practice directive, and we can do it in that manner. So upon receipt of a motivation of why the matter needs to be done on a face-to-face physical basis, we will certainly adhere to that request and consider it, and it will be conducted at our nearest regional or satellite office. On to adjudication. You would know that our adjudicators are akin to judges. They are completely independent and impartial, and they would determine an order dealt with on the submissions made based on the papers before the adjudicator. And at the discretion of the adjudicator, there will also be allowance for a face-to-face or a hybrid adjudication hearing upon request and motivation by the party requesting same. Our new practice directive also deals in a lot more detail with instances where non-attendance of one or both parties are applicable. And in this instance, we will refer you to those for your reading to see that you are adhering to whatever we need to consider when there's non-attendance of the parties. But in most instances, we see that parties are very much welcoming of the process and always willing to assist the CSOS in coming up with a final or a hearing in terms of finalization of the order. Then a very important other amendment on our practice directive is that with regard to section 51. So you will see that, for instance, in instances where there's arrear levy accumulations, where the levy is, or the arrears are now accumulated to an amount far more than the original amount claimed for in the application for dispute resolution, we call upon our adjudicators to do a section 51 notice wherein they ask for the updated levy statement so as to determine what the status of the arrears are at the date of determination of the application. So this just makes it a lot easier for the adjudicator to make sure that he has the updated information that is required to finalize the order. The section 51 notice can obviously deal with a whole lot of other issues that the adjudicator wants clarity on, and it is not limited only to this instance. Then, of particular importance and relevance to most is section 397B, and it's important to note that 397B is almost the other relief in terms of section 39, and it is in terms of what the chief ombud proposed, not in terms of I don't see anything that I can deal with under my application or in my seeking relief from the ombud, and therefore I can plonk my other under section 397B. The chief ombud's proposal is definitely only limited to the following: an order on an urgent basis, obviously for the disconnection of essential services such as water and electricity, those type of constitutional issues where you need a court order to disconnect these type of services, or in instances where there's a denial of access to the scheme, which is also very serious and which we need to do on an urgent basis. You will also know that we do have limited time periods with or timelines which is applicable to urgent matters, and it is much shorter than our normal resolution time periods. And that's for the reason that these things are exceptionally serious and that we need to make sure that these things are attended to immediately. Health hazards are also listed as one of the reliefs that can be sought on an urgent basis, but these things are more or less confined to, for instance, by example, if there's a serious issue of mold in the unit and it affects the health of the people living in the unit. It's not necessarily any health hazard that happens with regard to what people claim to impact on their application for dispute resolution. Then two new what's it called, reliefs that is included in here, is if you are dissatisfied with an EMA's performance. EMA is obviously the executive management agent, which was appointed by the CSOS, and this is then dealing with exactly that. Then there's also a provision for compliance with rules. There's a obvious error in the practice directive that we will be attending to amending very soon, because it obviously doesn't state that you will be compelled to comply with undesirable rules. That was never the intention. Also important to note is that a cost order would be applicable if it's found that the matter was not urgent. Then lastly, in terms of the appeal process, Section 57 governs the appeal process, and we all know that it's only on a question of law and to be applied for in the High Court when that is applicable within a 30-day period. We can also just reiterate in this instance that once an order is issued, the adjudicator as well as the ombud becomes functus officio, which basically just means that they can't take the matter any further and they can't comment on the matter any further. We have to reiterate again that CSOS can't self-review its orders. We can't explain an order of an adjudicator, nor can we really interpret anything that was done by the independent and impartial adjudicator. Obviously, this is something that in future may become the topic of discussion when we look at the legislative amendments of the Act. And we would really emphasize that once we get to discussions and inviting stakeholders to comment on the legislative amendments, that this is a burning issue that you really need to comment on so that we can take it further in the appropriate forum. So we can also just mention that only a court of law can overturn an adjudication order. And in the past, the practice directive have made provision for setting asides and all kinds of other things. At the moment, that is not permitted because it's not in line with the legislation, and only minor corrections, something like a grammatical error or a typo or anything that doesn't affect the outcome of the adjudication order will be considered. So that's basically in a nutshell what I can add to the party or to the discussion for the parties today. I know that Mr. Masilo has also mentioned that we need to take you through the situation with regard to the CSOS's backlog, which I will touch upon now. And then just in terms of that, I think we've gone out to market with many stakeholder statements to discuss this unfortunate situation. We do still have a backlog. We are still seized with trying to eradicate this backlog, and you will, as one of the parties to this proceedings today have said, you will get a message saying that it's awaiting allocation to adjudication. So in the interim, what we have done is we have gone to recruit a further supplementary panel of part-time adjudicators. Obviously, this is not in line with the ordinary HR type of a recruitment practice, but it forms part of a much more complex procurement and audit process, which does take a little bit longer, unfortunately. We have appointed recently a further 4 part-time adjudicators to assist, and we have also advertised again for the final supplementary panel to be completed and recruited in this manner. So that is underway with our procurement department. And then we can also just confirm that great progress are made with the eradication of the backlog. We have to unfortunately deal with things on a first in, first out type of basis, and we can't really give exact timelines with regard to when your matter will be heard. But we really do implore you to be patient with our process. We are making every effort to eradicate this backlog. So with that being said, over to you for questions.
Thank you so much, Charmaine. Sorry about that. I see we already have a hand. If you can stop sharing so that I can see the hands as they are being raised. Is it Trom?
The whole day.
There you go, sir. We hear you.
All right. Charmaine, just a question regarding the appeals process. And I ask this with some concern because I've seen that there's a lot of judicial debate amongst the courts, the Western, and this comes in terms of your directives as well, where the Western Cape Court allows something to be done ex parte, and when it comes to the Section 57, if there's a condemnation at the time that it has gotten to court, it tends to allow it. But here in Gauteng doesn't allow it at all. It sticks within what is within the legislation. So my concern is, as much as you've made these directive changes, have we engaged the judiciary? Because it's confusing for us as directors who want to comply, who want to give CSOS the support, when there's so much judicial debate, and we are confused as to, do we actually stick to what the Act says, or do we follow an internal directive where the courts can actually overrule that and say the directive does not match the legislation, and then we go on again on another judicial debate. So my problem comes because KZN has its own appeals process, Gauteng South, which is Johannesburg, its own. Gauteng Pretoria, where I'm at, has its own. Cape Town has its own, which is very different. So it confuses us who, I almost said subscribers, but homeowners and directors who rely on the clear interpretation of the Act, which then the courts seem to confuse. And so can CSOS then take us either into its confidence, and we can have these judiciary debates with them, so that we can have one law that we need to apply. As much as CSOS was taken to task by CN about not enforcing certain clauses, the courts are just as confusing us. And so I want to know what would happen then if the judiciary were then to say that the current consolidated directives are not in line with whatever interpretation that is within the legislation, because we have not made those legislative changes.
Charmaine?
Thank you,
Charmaine,
sir.
can I take
Yeah, sure.
can I take
Sure,
this
Anusha,
one?
you can
So,
take it.
Trom, good afternoon, and thanks that you have joined this webinar. So I'm one of the senior managers. I'm based in KZN, and I was a chief registrar previously. So the question that you have raised is a good one. And, you know, once the order is out by us, that's when our role in the process actually stops. And then if you want to take it on appeal, you would have to then take it to one of the high courts. So you have correctly pointed out that there's different practice directives, and some courts are doing things differently from the others. And that was one of the reasons that we've got now the chief registrars. So I would suggest that, you know, the chief registrar is actually the ones that need to take this further. It's completely out of our hands as to the process that follows in courts. And as Charmaine pointed out initially, that, you know, our practice directive can't override what is there in the legislation. So anything to do with following the different procedure, and the different high courts do different things differently. When you're lodging your appeal, I would suggest that you liaise with the chief registrar directly of that court to, you know, find out what is their current practice directives. There's different practice directives and practice manuals for each high court. So you liaise with that, you get that, and there's different ones on appeal processes as well. The last time that I was there, I know they were trying to look at standardizing the practice directive so that all the courts function in the same way when receiving, you know, they have their own sort of thing as to how the appeal should come in, how it should be bound, that sort of you know, guidance you can only get from the chief registrar at each division. And you are correct to say that it differs from division to division. but it is something that is beyond us. I don't know if you want to add on to what I've just
Yeah.
said, Shame.
Sorry, I would.
Thank you, Renisha. Just also to not be confused, condonation in the court process as opposed to the condonation application in the CSOS process. Ours are simply limited to the 60-day timeline with regard to meeting issues, whereas condonation on an appeal process is a whole different kettle of fish, which is part of the court process. Mr. Trom, I trust that we have answered you.
Yes, sorry, there's just one thing that I left, and I don't want to hold up the other forest of hands. The thing you said somewhere about an urgent, urgent application regarding restriction of access control. Currently, the High Court in Pretoria has asked that the Superior Court must now intervene in terms of the restriction. Is CSOS still then capable of adjudicating in such things when the courts have thoroughly, again, confused themselves? That one court has now asked that, can we just get clarity, much like we did with the Marsh Rose principle regarding the embargoes on, on area levies?
Okay, there's definitely much in the judicial space regarding this, but I'm going to ask Mr. Masilo, my regional ombudsman, to take that question. Please, Mr. Masilo.
Thank you, Charmaine. Yes, we are aware of what's going on in courts currently, particularly this matter, and we will continue to monitor the situation. However, much as the courts, you are saying, are still confused themselves with regard to this restriction, we will continue, obviously, to order in terms of the applicable, obviously, jurisprudence that has been created currently, until such time that the Superior Court has made a determination. But that does not mean that then one is interdicted, if I may say that, from obviously issuing those orders. It is only until that Superior Court has made that determination to say, now tell us what is happening. We hope that they will be able to note the agency of this issue and perhaps maybe provide an order, a clarity as soon as possible. So yes, we are monitoring that, and we will proceed as such until such time that we are directed by court. If you look at our practice directive, what we're saying is that in most instances, we will then obviously follow, the court's decisions. But you must understand, if it's a court decision in, say, KZN, you might find that and this is what caused the earlier question that you raised with regard to the appeal process, to say you then get that divergent decision from other courts in, say, in Gauteng, as well as in Western Cape, So from time to time, we still find that challenge. But there's also a key question that you asked to say, are we also obviously consulting with the judiciary? And the answer is yes. As we speak, next week we are to see the magistrates, the chief magistrates in Gauteng here. We are having a meeting with them. And then from then onwards, obviously, we will obviously be conducting these meetings, sessions together with, the high courts as well, to make sure that, we are aligned as far as, our legislation is concerned versus the court's processes, to ensure that, there are no gaps. But yes, we are awaiting that outcome as well. Thank you very much.
Thank you, Masilo. Thank you, Ombudsman. Mr. Trom, I hope that we have answered you, but I think it's also worthy to note that the law is a messy business. And when there's two attorneys in a room, there's generally 17 opinions. So we need to just be bearing with the process and making sure that we get somewhere with these many different judicial issues that we are faced. Thank you.
Thank you, Charmaine. Can we proceed and go to Louise Treisman? Louise? I think you just have to unmute. Okay, there we go. Okay, looks like Louise is experiencing some technical glitches. Can we proceed to go to Isel? I think it's ILZE.
That's
Yeah,
it. Yes. Can you hear me?
Yeah, we can hear you, ma'am.
Perfect. It's Ilse. Thank you very much. I think by the sounds of it, I think it's not, or it's common knowledge, and that the adjudication processes are so overloaded at the moment. My concern is just we currently have 2 matters awaiting adjudication against, I'm the chairperson for a body corporate, and the matters pertain to the termination of our managing agent. But now and having moved over to another managing agent, it turns out that we are facing potential financial liabilities as a result of the mismanagement by the terminated agency. My concern is, as I've heard via the grapevine, that this particular managing agent is also in the process of shutting its doors. So how do we expedite a matter, so that we can try and minimize the financial impact on our body corporate? How do I get traction on these 2 matters?
Thank you for that question, Charmaine, or do you want to tackle it?
Maybe let's refer that one to the AAG, who will obviously apply her mind and deal with it. I think you'll share the email address of the acting AAG so that this matter can be dealt with separately. I don't think it's a matter that we need to discuss it in this forum. Thank you.
Thank you so much.
We will have to perhaps maybe write on the chat group so that we can have all your details so that the AAG can then revert back to you. And please
Fantastic.
also provide the reference number as well.
Fantastic. Thank you very much.
Thank you so much, Mr. Masilo. Can we proceed to go to Adrian? Adrian, if you can unmute. Okay, it looks as if he's struggling. Also, can we go to Paki Zandile, Mr. Paki Zandile?
Thank you very much, Babu Vava. Mine was going to be a question, but I will just reduce that into a comment because Babu Masilo has already covered what would have been a question from my side about the alignment with the practice directives that Ubabu Trom was alluding to earlier on, what is happening in Gauteng, in the Western Cape, and in KZN. So for me, really, the concern raised was that I think it's very important that CSOS looks at its documents and try to see what is exactly happening within CSOS vis-a-vis what is happening at the courts, because it's quite clear that there is actually a confusion insofar as this is concerned. So my comment really is Ntate Masilo has already said there is a need really, in fact, you are continuously monitoring what is happening in our courts so that if there is a need really, let that be translated into realigning your documents accordingly. I also want to believe that this realignment or alignment with what is happening in our courts will assist, in terms of seeing to it that there is actually compliance, because earlier on, Ms. Molefe was also talking about that CSOS does not want to adopt the adversarial approach, even though, I myself and other colleagues who are online, one attendee actually said, what's the use of these if they are not going to be enforced? So, and I want to believe that insofar as these disconnects are happening, one way or the other is actually something that is going to contribute in people not taking CSOS not taking CSOS seriously. So my really take is that I think it's time, given how long now CSOS has been in practice, it's time that CSOS must really align itself accordingly. Yes, I understand that it's not going to be easy because provinces adopt and practice differently insofar as their PDs are concerned. It is going to be a challenge. However, I want to believe that with the representatives, as Ms. Molife has actually said earlier on, that there are people who have been dispatched countrywide. They will actually take on these comments and collate them and consolidate them to see to it that for the next 8 years, how are we then going to see to it that CSOS really does what it is actually meant for? Babu Vava, ngiyabonga baba.
Yeah, just
and
also before maybe just to wrap up on this point of divergent decisions. And I think in law, it's important that you share, our shared living with, everyone here. That in the past quarter, I have dealt with the different approaches as far as it relates to Section 57 by different courts. And I have coined it the appeal maze, wherein I give a sort of a process for each division, particularly the KZN. I have also the Gauteng way as well as the Western Cape way. So I think it is important that from time to time, when we get such a divergent information, particularly during this judicial debate, that we from time to time share it with everyone, and we are hoping that you would be able to receive our shared living, but clearly you did not receive our shared living, which is our magazine, wherein we from time to time disseminate this information, write about the various challenges, write about the solutions, write about what is it that we are doing as the CSOS. And it is for this reason that I'm saying, Vava, please make sure that you share this immediately after this with everyone here, so that they have a copy of our previous shared living where I dealt extensively with those three processes from those three divisions. Thanks, Mr. Baba.
Thank you so much, Mr. Marcelo. Let me jump on it. If you would want to receive a copy, please leave your email addresses, unless we can be able to retrieve your email addresses from the registration link, we will advise on a later stage. Can we go to Adrian again? Adrian, your hand is still up.
Hear me?
Yes, loud and clear, sir.
Hi. Good day, sir. Charmaine mentioned earlier that CSOS was looking to appoint more adjudicators to deal with the extensive backlog. Will CSOS publish a list of those adjudicators?
Yes, we are using we are appointing them in terms of a procurement process. And in terms of the procurement processes, we are duty bound to make sure that all your service providers, you are published. You have to publish your service providers because it is a requirement in terms of treasury regulations. So yes, we do publish them. Once we do the appointments, we publish. So you will be able to see also those that will be appointed, particularly with regard to the tender that closed last month on the 22nd, if my memory serves me well, wherein we are now busy with the other valuation of all those bids that we've received or responses that we've received. And therefore, once we do the appointments, you will certainly see those names as published. Thanks.
Okay.
Baba?
Where do we find the current list of the adjudicators that's
Yeah,
published?
the current ones are in the Treasury port, and that's where you'll be able to see the published names, all of them. But there is nothing untowards in us, obviously sharing the list of all these adjudicators with you.
I refer you to Section 46 of the CSOS Act, which states that the Ombud, on application by an affected person, allows such person to inspect and obtain copies of the current list of adjudicators. So, as owners, can we make a request? Can we send an email, and would the Ombud provide us with that current list?
Yeah, Adrian, that's a slippery slope that you are entering now. If I may say that to you on a lighter note, if you read at that provision that you've just indicated now, and I don't think I would want us to get into the provisions now, unless we interpret things beyond what we should have interpreted. It says that if you have paid the levy for the adjudication, then the Ombud must then provide that. And now what we have done is that we have provided what we call a waiver for all the CSOS adjudication levies. So there is no CSOS adjudication levies that is required, to an extent that we have provided an upfront waiver for everyone. So that provision only applies if a CSOS levy adjudication for levies have been paid, and we have provided that waiver. But as I say, you should be able to get that. It shouldn't be, it's not a secret to us to have these adjudicators. But the question is, we would want to know, what is it that you want to know about them? And obviously, hence, I'm saying to you that you do find the list from the Treasury port, wherein they publish all the service providers, not only of CSOS, but of all state-owned entities, including government service providers are published there. Various tenders, all the tenders in terms of their tender numbers and everything, they are published there, including obviously the appointed service providers as such. So everyone is there. Thank you.
Okay, the reason why I'm asking, for this current list of adjudicators, and in dealing with the backlog, I mean, it's been like 2 years. CSOS has been telling us that they're dealing with the current backlog, and that they're appointing more adjudicators all of the time. But we are actually not seeing a difference in terms of the turnaround times of adjudications being handled timeously, of CSOS actually adhering to their own timelines that are stated in the Consolidated Practice Directive. CSOS is a creature of statute, and it expects owners, it expects applicants to adhere to those provisions, but CSOS themselves do not adhere to their own statutory obligations, and that puts us owners under a great deal of distress. So that's why I would like to make an application for the current list to see that of the adjudicators, to ensure that so we as owners can see that CSOS is doing their job in appointing more adjudicators to handle these matters.
So we can assure you that, so we can assure you that we are embarking on this process, and I think we've answered your question with regard to where to obtain this list, and the fact that we are busy underway with another procurement process to appoint a final supplementary panel.
Okay, just one quick question. How many adjudicators does CSOS have?
6 internally, and then approximately 30 externally, but I'm not exactly sure of the exact number, because we've just, as I said, recently appointed an additional 4.
So we can say, let's say under 40 adjudicators. And how many applications, are there for adjudication countrywide? Is it in the tens of thousands?
If I can just explain that in the past year, the past financial year, we received a total of approximately 17,000 applications for dispute resolution. Obviously, a number of those are settled at conciliation, so I can't give you an exact figure, but this is so voluminous because in the previous financial year to that one, we only had about 10,000 applications for dispute resolution, if that puts it in perspective.
Okay.
Yes,
Understood.
and just to add on to that, Adrian, sorry, it's Renusha from the KZN region. We must always bear in mind that yes, we do have the adjudicators, and yes, we are adding on to them. But behind every CSOS reference number is a person. There's a person behind that. And when these adjudicators are dealing with these matters, it is not just a tick box exercise. I'm just going to deal with this adjudication order and get this out of the way. It's not like that at all. They have to apply their mind and pay attention. And if they need to request further information from the parties, then they're going to do that. And then after that, it has to go to a quality assurance internal vetting system to make sure that the orders that are delivered and given off is legally sound and a proper one that is before the parties. And then it goes back to the adjudicator so that the adjudicator can take into account whatever the quality assurance team has actually brought to their attention. Then they apply their minds once again before that final order is sent out to the parties. So it's not we can look at statistics, yes, by all means, but please don't forget and don't lose sight of the fact that there are people behind these reference numbers. There's a legally qualified adjudicator that wants to do justice to each and every matter. And yes, when we go back to the list, and although you can obtain that list from Treasury, when you do contact us and you do get in contact with us for one specific matter and you say, listen, give me an update, where is my matter? Or I have an interest in this matter and I'm the respondent or I'm the applicant, we then do tell you this matter is with adjudicator, this. And that adjudicator also gets in touch with the person. So it's not as if, what I'm trying to say is that there is contact with the adjudicator. We can provide the statistics, but the thing is, it does take time, and it takes time because we want to ensure that a quality, legally sound order is out to the parties. So I hope that helps.
Just to complete this, in conclusion, Adrian, I was just looking at the number of matters that we finalized. I'm just going to run through quickly monthly how we have fared before and what's the difference post obviously the appointment of another batch in February. End of February, we slightly got at least another batch to increase to the number that Charmaine was indicating earlier. In January, and that obviously was because of a number of reasons. It could be that we are, it's that short period due to obviously the festive season. People, some of them are not available to provide responses and so on. We did about 38 applications that we finalized in January. In February, we did 198. And then by the end of that February, we were able to at least add additional of about 13 or so odd from the number of responses that we received of the new pool of adjudicators. And we did 564. And we moved like that in April, 526. In May, we did 562. In June, last month, that other month, we did 603. And in July, it's 560. So these numbers, if as soon as we add the other adjudicators, our target is to be able to at least do at least an average of about 1,000 adjudications, finalization of adjudications per month. And that, as Renusha is indicating to you, that you cannot just quick do just that order. Some of them, they differ from one to the other. Others are a little bit straightforward. It's easy to deal with. Some of them are not as straightforward as that. Some of them we still do the virtual hearings, as Charmaine has also indicated. So there's, each case is treated on its own merit, and some of them, they will take slightly longer to be finalized. And these are the challenges that we get from time to time. But there is that positive trajectory that shows that, we have improved in terms of the number of, finalization of these matters, with the hope that, as soon as possible, we should be able, by the end of Q3, to finish the entire backlog, so that we do not have this backlog going forward. Yeah, I hope I have covered that. Law, you can take over to the next one. Thank you very much.
All right. Thank you, sir.
Thank you so much, Mr. Masilo. Can we move forward to Lerato Miyaga? If you can, yeah, there you go, ma'am.
Good day, everyone. I think I'm covered because I was going to elaborate on Elise's point that what do we do with managing agents that have now gone and closing down their shop while we're still waiting for adjudicators to be allocated. So they're literally getting away with putting complexes into debt, and no action was taken against them. And also, it's not only your backlog, even when with the cases that we've taken to the High Court, again, the High Court also has a backlog as well. So I don't know what to do with this. It's just a double-edged sword.
Okay, thank you that you are
So
covered,
secondly,
Lerato.
you correct, Lerato, because I'll tell you, even the erstwhile former judge president of the Gauteng High Court here, he did indicate that, there are delays everywhere with regards to this. But that is not an excuse. We need to make sure as CSOS that, we capacitate ourselves to an extent that we are able to deal with these matters as an ADR, as an alternative dispute resolution mechanism that is available for people, to an extent that we are able to dispense justice as quick as possible. And not make the fact that everywhere there is that. But I can assure you, Rato, there is hope. We are getting there. We are about to at least deal with the backlog, and we hope that at least the end of next month we would have appointed at least another additional adjudicators. We have noted that during the evaluation of these responses, that there were challenges wherein the service providers, in this instance, the adjudicators, part-time adjudicators, were unable to actually respond because some of the things they did not understand. And we have dealt with that in terms of the TORs that were issued recently. So you can understand that we hope that in this batch that we have received now recently, we should be able to get at least quite a lot of these adjudicators and be able to eradicate this. It's not an excuse, Lerato. We must do what we need to do and ensure that we finalize this matters as soon as possible. Thank you, Lo.
Thank you so much, Ombud. I think I can hand over to you for the closing remarks. Okay, I see that there is a hand from Mongezi Velem, Mr. Masilo. Maybe we should give him an opportunity. Mongezi?
Yes, Mlo.
Mongezi, you might.
Thank you.
Okay.
Thank you so much, Mlo, and good afternoon to everyone. Just before Mr. Masilo closes the webinar, I just have a comment, or rather a plea to our stakeholders. It's in relation to this, to the thorny issue of, I will refer to it as such, of the backlog, the adjudication matters. To our stakeholders is, maybe let me start by saying we need to understand that CSOS was mostly established. In fact, it's one of the things that we promote, that people live harmoniously in their community schemes. So to achieve this, you will notice there is a first stage of our dispute resolution process, which is conciliation. So my plea to the stakeholders, when you are invited to that meeting, you need to delete the idea of adjudication in your mind and change your mindset towards an amicable resolution of the issues towards the issues that you have raised in your application, so as to work with us in alleviating the pressure that is experienced by the adjudicators. So the moment you receive an invite for conciliation, you need to gear your mind to an amicable resolution, go to conciliation, knowing that you might agree to something that is less than the relief that you seek or you have sought in your application form. So it needs to start there. Charmaine mentioned that the conciliator cannot force parties to enter into a settlement agreement. It comes from the parties themselves that they come up with the terms and conditions of resolving their matter. So we need to start there, ladies and gentlemen. When you are invited for conciliation, erase adjudication. It should come as a last resort in your mind if there is no agreement at conciliation. So you need to gear your minds towards resolving a matter amicably at conciliation. That will solve the issue that we are sitting with currently. Thank you so much, Mlo.
Thank you so much, Mongezi. Okay, Marius Potgieter. If you can unmute yourself, sir. Marius. I think he's struggling, Mr. Marcelo. Can we hand over to you, Mr. Marcelo?
Hello, can you hear me now?
Loud and clear, sir.
Perfect.
Thank you, Mr. Program Manager. Actually, my question I want to address to Charmaine. Is she still on the call?
She is, sir.
I think it is Charmaine. Charmaine, if it's not a slip, can you put your presentation on the slide before the thank you slide, please? Okay.
There we go.
Thank you. I just want to find out if the adjudicator made her or his ruling, and that ruling is now escalated to the High Court, and the ruling is now overturned. What then? Will the costs, the legal costs, be covered by CSOS? What are the consequences?
So, Mlo, with your permission, may I answer?
Go ahead, Charmaine.
Thank you. So the appeal process falls completely outside of the realms of the CSOS process. So if a party elects to go on appeal, obviously this is for his or her own cost. This is not something that the CSOS can consider or do. And as I said earlier on, there are many different interpretations in law of many different instances. So it is not necessarily only in instances where CSOS has issued an incorrect order that a matter can be overturned on appeal. There's many things that need to be considered. So there's no hard and fast rule with regard to that. The only thing that is hard and fast is that we will not be carrying the cost for that, if that answers your question.
Yeah, you do. You do address my question directly, but if you look at it now from another angle, if you look at why CSOS made a ruling, and if you look at the reason why the High Court judge or whoever overruled it, then I hear you to say that if you got two perhaps adjudicators in the room, you will get 17 different results. But that is a serious gap, because it's costing whoever now an arm and a leg to get the correct ruling with regard to the case, because you won't go to the court if you don't think you've got a solid case. Do you hear me, Charmaine?
Yes, I do, sir. And I can assure you that our adjudicators act in a professional manner, evaluating all the evidence before them and regarding the merits of the specific matter. So I can assure you that every effort is made to make sure that we issue legally sound orders.
Yes, can I just add there, Charmaine? So what happens is with the adjudicator, they are equivalent to like a judge in a high court, a decision maker, basically. And just what they would do is they would look at the law and then they would apply their mind to the law. So you would get adjudicators that would look at previous adjudication orders and see how that was dealt with and may rule similar to their colleagues, but they're not that's just persuasive, you know. At the end of the day, it's an interpretation of what they think this set of facts is and how they look at it in line with the law. So that is why you may get different results. And I think your question was asking about costs when it goes on appeal, then determining there whether what the judge then ruled, because I'm taking it that it would obviously appeal in the High Court, then the judge there would look at what was the outcome, what was the decision, and then there they would look at who needs to bear the costs of this appeal now coming there. So I don't know if that answers you on the question of costs and on the question of the different decisions as well.
You've helped me now. I'm talking to Louise.
No, it's Renusha from
Renisha.
KZN.
Renisha.
Yeah.
Okay, Renisha. Yeah, thank
Yes.
you. You've pointed me now there. What I just want to find out, you said the adjudicator will look internally. Should the adjudicators and look for a similar case, should they not look towards results from the High Court in specific areas where that's internally available was overturned by the High Court, and rather act on that than on the internal process, which is then I'm not a legal eagle. I don't know the right words, which
Yes.
is flawed. You know,
No.
flawed is not
Yeah.
the right word. Yeah.
I know but I do hear what you're saying. So the adjudicators do consider case law. So it's case law that you're mentioning. And they often do cite this as well in their adjudication orders. So, and they do the research that is required in order to come up with the order. And we are also looking to better our research tools and all of that. So I think that would have now covered your question.
Yeah. No, this is great stuff. Thank you. So if you put a case to CSOS and you've got a High Court's decision on exactly the case you're busy with, and you quote that also in your submission, I guess that would help a lot and will go a far way.
Yes,
Yeah?
definitely. So as we discussed in the beginning, your application is going to be limited to 10 typed pages, but different from annexures. You know, it excludes annexures. So you can mention the case, and if you've got the case, you can attach that as one of the annexures. And then obviously the adjudicator would have a look at it, and we cannot dictate to the adjudicator what to do. They are independent in their decision making, right? So they will look at that authority, case authority that you furnished, and then they will consider. And then if there's something that overturned that or looked at it in a different light and it's more recent, then they may decide to use that in their adjudication order and bring that to your attention as well.
Thank you very much. And also thank you to Charmaine for her presentation.
Thank you so much, sir. Can I
Thank
hand
you,
over to
Program
Hazel?
Manager.
Yeah, thank you very much, Marius. I think those were quite important questions that you've asked. Just to indicate that in closing that, you know, we do have currently the judicial debate, and it's a matter of the Vodacom matter versus Makate. We all know that the courts are saying that you know, the duty to proper consideration, you know, wherein they actually created those new constitutional standards with regard to the duty to of proper consideration and a duty to provide reasons. You will note that Makate had obviously a clear belief, same as you, to say that his case will be the end of it at the Concord. But the Concord has referred the matter back to High Court to say, and they were very scathing to the High Court. So this thing of you know, different interpretations, so it happens from time to time everywhere. So I just wanted to mention that to say why I'm saying it is important, you know. But colleagues and to everyone, it was quite a lot to take, although this afforded us with the opportunity to address, you know, other issues outside of the agenda items, which, you know, we truly welcome. And I must also indicate that we received a number of inputs, and some were accepted during the drafting of the practice directives, and some obviously were not, you know, accepted as such. And obviously, we have provided reasons why they were not, and we will respond as such as far as that is concerned. I must also indicate that we strive to promote accountability, transparency, and ethical conduct, and we will still get, you know, a pushback from time to time, you know, with people who are saying that, yes, we see that you strive for that, but, you know, there is that pushback from time to time. But with the new interventions, you know, the PDs, which we strive to align with our current legislation, which I said earlier, you know, our current legislation, the only challenge is that we are a creature of statute, and anything outside of the four corners of our legislation will be deemed ultra vires, and therefore we can't deal with issues that are clearly outside of, you know, our legislation, unfortunately. And this talks to those issues after the Section 57, you know, the PDs of various courts and so on. So we have indeed touched on them, you know. And some are attempted to even address the current, you know, some of you that were here also, you know, attempted to obviously address the current matters which they have. And the unfortunate part is that we can't get into the merits of those matters directly, because obviously those matters are sub judice, and, you know, they are still underway. You know, they are still being dealt with by, you know, various people within our organization. I must take this opportunity to thank you for the attendance of this webinar. We will continue to also, you know, with additional training sessions or webinars until we finalize these new PDs. I think it is important. Of importance is that we are also able to even address other issues, which, you know, we really appreciate. And Mlo, I think you have also indicated the next webinar, the date for the next webinar. Am I correct, Mlo?
That is correct, Mr. Marcelo. I have it on screen.
Yeah, you have it on screen here. Yeah, and thank you very much to everyone. We hope that you will attend again in numbers in our next one. And as we say that where we have the opportunity to deal with other issues, we will do so. we will try and deal with whatever that is possible for us to deal with. Those that are a little bit require us to deal with them outside of this, you will note that, I have also even attempted to give, or respond to some of, the questions, not only here on this platform, but also using the, typing on the chat box. I've also provided my email address. I hope, Mlo, you will also provide the email address of the AAG, which is quite important for the, the people who attended here, so that, they are able to escalate those matters wherein they feel that they need to. However, all our senior managers are here. May it be for governance, from Ms. Mulefe, who was here, Charmaine, Renusha, as well as Thora. I haven't heard anything from Thora this afternoon, but she is here in attendance as well. And as we say that we are all available together with all the ombuds, and and thank you very much also to Mulo, to you also, Mervyn also. I know that you are here also. The ombud of KZN is also here. And with that said, have a good afternoon, and thank you so much. And let's have another session, very interactive session indeed. And have a good afternoon. Thank you. Bye.
Bye, colleagues.
Thank you. Bye.
Bye, everyone.